How to monetize intellectual property. An introduction to intellectual property. Hello, Joel Douglas here. I am an instructor, guest lecturer at the Shelby Colum Davis Professor of American Business and Economic Enterprise at Trinity College. Thank you for watching this series. I decided to do this series on intellectual property and how to convert your ideas into a business after being approached by a number of entrepreneurs who had what appeared to be very good business ideas but did not know how to start them. The series will provide you a brief roadmap on how to protect your intellectual property and a brief explanation on how to form your business and the steps that you need to follow to grow your business. Here's some background on my entrepreneurial life. I've started 3 successful companies and have been granted 96 patents and 13 trademarks by the United States Patent and Trademark Office associated with the development of those business interests. I formed Nuventus LLC to assist companies and entrepreneurs to develop and successfully commercialize new products. J. Paul Getty, former oil tycoon and richest American, once said, "There is one way to make a great deal of money, and that is in a business of your own." That's a very true statement. But I'd offer the following modification. There are 2 ways to make a great deal of money, and the first is to own your own business, and the second is to invent and commercialize a product or service that a large number of people need and want. The second part of this modification is the focus of this lecture. Intellectual property, IP for short. To understand the significance of my revision to Getty's quote, we need to explore intellectual property, how it's created, and its contribution to wealth creation. Let's start. Individuals and businesses that leverage intellectual property to create wealth do so utilizing one or more of the 4 primary instruments available to protect their intellectual property. These instruments include trade secrets, trademarks, copyrights, patents. Let's examine each type. Broadly speaking, any confidential business information that provides an enterprise a competitive edge may be considered a trade secret. Trade secrets are the most difficult type of intellectual property to protect and are more difficult to monetize. It is best understood by looking at well-known examples. Coca-Cola specifically. The secret Coke formula the company has maintained as a trade secret. The problem is that somebody could independently derive the secret Coke formula, and there is no way for the Coca-Cola to protect the formula, because if an applicant abandons, suppresses, or conceals the invention, they may not be entitled to a patent. Therefore, by employing a trade secret, you may not be able to prevent another company from independently deriving the invention and using it in commerce. For this reason, trade secrets are rarely used and may be ineffective when utilizing them with respect to wealth creation by small companies or by entrepreneurs. Successful entrepreneurs and businesses create recognizable artwork and logos to establish and enhance products and services and brand awareness. Trademarks are symbols, words, or legally registered or established by use as representing a company or a product. Some iconic examples include the Nike swoosh, Ford emblem, Coke logo, and the list goes on. By using trademarks, the intellectual property they represent provides the consumer with continuity of the brand and the quality it represents. By imparting brand awareness, recognition, and exclusivity, trademarks drive products and services. Monetization. Here's an example. Heinz is a household name, and the brand is well known for ketchup and the quality product that the brand represents. When Heinz introduced mustard and other condiments to its product line, they were instantly recognized, and the pricing power of those products was greatly enhanced by marketing them under the Heinz trademark. Strong brand recognition driven by the intellectual property identified by the established trademarks drive commercial success. Musicians, photographers, and authors use copyrights and trademarks to protect their literature and music. A copyright is an exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record literary, artistic, or musical material, and to authorize others to do the same. Examples of these include J.K. Rowling's copywriting her Harry Potter books, or Jimmy Buffett copywriting his song Margaritaville. Both people have used the copywriting process to leverage their intellectual property, and in this case, literature and music, to generate significant wealth. They have used their artistic and inventive genius to produce intellectual property with tremendous appeal, longevity, and multiple revenue stream opportunities. Another avenue to create intellectual property for creating wealth is obtaining a patent, which is a government license conferring a right or title for a set period of time to exclude others from making, using, or selling an invention. Entrepreneurs and companies obtain patents to protect their inventions, including machines, manufacture, compositions of matter, or a process. The concept of a machine is easily understood. Examples include familiar items from coffee makers to iPhones. The concept of a manufacturer is slightly more difficult to understand, but may be represented by the development of a product such as special paper for printing money. Composition of matter spans a variety of product types, such as formulation of ink for an inkjet printer, formulation of a new drug compound, or formulation of a stainless steel alloy. The concept of a process might be designing a new business process or a method for preparing peppers for a new hot sauce. Patents are useful for protecting a variety of different types of invention. Thank you for watching, and I look forward to seeing you again for the second video entitled Creating, Protecting, and Understanding Intellectual Property.